She signed the divorce papers, then allegedly stole his entire school. She signed the agreement on a Friday. By Monday, she was already breaking it, or so her ex-husband claimed. When the marriage ended after 11 years, the division of assets was complicated enough. But what made the divorce of a private school administrator and her ex-husband truly unusual was what she left behind on her way out the door and what she allegedly took with her. The plaintiff in this case was the founder and director of Crestwood Academy, a boutique private elementary school he had built from the ground up over 14 years in a mid-sized suburban community. He was by all accounts a passionate educator, the kind of man who answered parent emails at midnight and knew every child's birthday. He was also, by many accounts, a controlling husband. The defendant was his ex-wife, the school's former director of curriculum, who had worked alongside him for 9 of their 11 married years. She had written the school's entire academic program, every unit plan, every assessment rubric, every pedagogical framework that made Crestwood what it was. When the marriage collapsed, so did the professional partnership. As part of their divorce settlement, she signed a non-compete agreement in March, prohibiting her from working for any competing private elementary school within a 30-mile radius for a period of 3 years. In exchange, she received a buyout of her equity stake in the school. 6 weeks later, she accepted a position as curriculum director at Harlow Preparatory, a private elementary school located exactly 19 miles from Crestwood's front door. He sued her for $340,000, the full value of her equity buyout, plus injunctive relief compelling her immediate resignation from Harlow. The plaintiff's case rested on one pillar, and that pillar was granite. She had signed the agreement. Her signature was notarized. Her attorney had reviewed it. The language was unambiguous. And now she was sitting in a competing institution, presumably doing the exact same work she had done at his school, work he had compensated her for through that buyout. He testified that within 2 months of her joining Harlow, 3 families had withdrawn their children from Crestwood, citing curriculum changes. He presented invoices showing $67,000 in lost tuition revenue in a single semester. His voice cracked when he said he had built that school with his hands. It was hard not to feel for him. Her attorneys argued that the non-compete was unconscionable in its scope and coercive in its origin. They painted a picture of a negotiation that was anything but equal. A woman finalizing a contentious divorce, under financial pressure, represented by an attorney she'd only retained 2 weeks prior, signing a document she felt she had no real power to refuse. They argued the agreement was not a standard business arrangement, but a punitive mechanism designed to sideline her professionally. They noted that she had not solicited a single Crestwood family, had not taken any proprietary documents, and had simply accepted a job offer in her field. Educators, her attorney argued, cannot be prohibited from educating. She testified quietly. She said she had loved that school. She also said she had been afraid of him. Then came the text messages. Submitted by the defense during discovery, the messages were exchanged between the plaintiff and his attorney in the weeks before the divorce settlement was finalized. In one exchange, dated approximately 10 days before the non-compete was signed, the plaintiff wrote, and these are his words, "She'll sign it. She needs the money and she doesn't know what Harlow's already offered her is worth. If she figures it out, we slow walk the settlement." The implication was devastating. He had known about the Harlow offer before she signed the non-compete. He had not disclosed this knowledge. His attorney had not disclosed it. The non-compete, rather than protecting a legitimate business interest from an unforeseen future threat, appeared to have been constructed specifically to block an opportunity he already knew existed. The judge ruled in favor of the defendant. The non-compete was declared void and unenforceable, not on the grounds of geographic scope, but on the grounds of inequitable conduct during negotiation. When one party to a contract possesses material information relevant to the other party's decision to sign and deliberately withholds it, the agreement cannot be enforced in good conscience. The plaintiff was awarded nothing. He was ordered to pay $28,500 in the defendant's legal fees. She remained at Harlow Preparatory. He appealed the ruling, and the appeal was denied 8 months later. Crestwood Academy reportedly saw a modest enrollment decline the following year, though it remained open. The two have not spoken since the verdict. He built a school out of love for children. She built its soul out of love for teaching. Whether either of them acted out of love for each other, by the end, seemed genuinely unclear. Here's the question the case leaves behind. If you discover someone is about to make a decision that benefits them and hurts you, are you legally or morally required to tell them?